Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights issues and legal issues, bringing you information and analysis. My name is Thuli Madonsela. Remember, you can also be part of our discussion today by tweeting us at Rights and Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. At her appointment by President Jacob Zuma in 2009, Thuli Madonsela faced a challenge to establish a truly fearless and principled pursuit of efficiency and honesty in government at all levels of public administration. She came to the office steeped in the traditions and activities of the anti-apartheid movement. Prior to 1994, she had been employed mainly in the trade union movement and as an academic, both in teaching and research. But after her freedom in 1994, she had an extensive service across many departments within the public service. She is formally described in her official profile as a human rights lawyer, equality expert and policy specialist with 2 decades of post-legal qualification experience. Today on Rights and Recourse, we are looking at Thuli Madonsela's legacy. In the studio with us, we welcome Advocate Thuli Madonsela. Good afternoon and welcome to Rights and Recourse.
Good afternoon. Thank you for this opportunity.
The question is, what I read, that the introduction I made was in a citation for somebody who was commending you for a honorary doctorate, and I came across this, and it gives a good explanation of yourself. You might want to refute it, but who is Thuli Madonsela?
I'm a girl from Soweto who spent most of my time between Soweto and Swaziland. And as early as 18, I got involved in protecting the public from excesses of the apartheid government, mostly as a trade unionist, and then later as a leader in the civic movement. I also got involved in the broader struggle in the underground activities thereof.
How has your world changed since your ascendancy to the office of a public protector?
I would say the greatest change is the fact that more people seem to know about what I do. I've always done work which has been about helping people to vindicate their rights and advising those who are involved in policy work and public management work. That was done in private, except for the stint when I was at the South African Law Reform Commission. Being Public Protector has thrown me into the public light and into the world stage. But I think the greatest thing, though, has been that through this exposure, we were able to reach the Gogo Dlaminis wherever they were, physically, as we traveled to far-flung places such as Postmansberg, and through TV and radio, using such interviews as this one.
Did you have, I like the Gogo Dlamini story because I do ask a question around the Gogo Dlaminis, but did you have any expectations when you walked into that position?
I did. I thought that it was always going to be a platform to do what I'd always loved to do. I'd always been involved in helping people vindicate their rights, be it against Home Affairs, SABC, local governments, etc. And I thought this would give me an opportunity to do this work with authority. I also thought that it would give me a platform to use that office to implement alternative dispute resolution, which is really about returning agency to the people and allowing people to sit like me and you here with ministers and find answers to their problems, and for the ministers, DGs and leaders in municipalities to see the pain they may have caused through their actions, even if they didn't intend to do so. So those were my expectations. I think most of those expectations panned out well, but there are some things that I didn't expect that happened too.
Many people believe that the Office of the Public Protector, as you say, you mentioned mediation, should be a kind of office where you bring the minister or whoever is responsible for it to have done something and did not do it for the Gogo Dlaminis, together with the Gogo Dlamis, and then they must ask the questions to that person, and that person must give the answers.
Certainly, I think for me, that's the joy I take away from that office. Leveling the playing field and getting the little David and the Goliath on the one table, but combined by their shared understanding of the Constitution and the values beneath that Constitution. And I found that when you bring people together, even if there was stubbornness on the part of government, once they see the harm that has been caused to the person, and once that person speaks in their own voice about what really happened and how it impacted negatively on their lives, I see people's faces changing, and the opportunity for people to say, okay, yes, we made a mistake and we're going to fix it, is enhanced through ADR.
In a glowing tribute by Judge Dennis Davis, who at the time was the director of the Center for Applied Legal Studies, he says you worked in the 1990s with people, strong-minded people, and strong-willed and strong-minded people like Judge Edwin Cameron, Holton Cheadle, Fink Haysom, and Paul Benjamin. How did these people influence your persona?
I think the greatest influence was their commitment to the vision of a South Africa for all, a vision of a South Africa where color doesn't really matter. We're judged by the content of our character as opposed to our skin color, but also their commitment to making sure that the impact of apartheid is eradicated. So there was no illusion that because we're the new constitution, we're now equal. It was always understood that we'll have to work. But also what I learned at CALS was respect for the rule of law, and that our job as academics and as lawyers is not to protect the state. Our job is to protect the people. And as a public protector, I came into this job not to protect the state, because there are agencies that protect the state. My job was to protect the people against the state when the state is involved in misconduct, and also to help the people to protect themselves when the state misbehaves.
In your job as a public protector, did you get a sense that many people didn't understand the meaning of the Constitution? How strong let alone the Public Protectors Act?
I actually found that many did, though. I mean, Andrew Snell, for example, Deputy Minister Andrew Snell, was one of those who, throughout our good governance conferences, he would bring to our attention extracts from deliberations in the ANC. Whenever the noise started, he would have a quote from what they discussed and what it means now, that they anticipated that this office could investigate matters that would disgrace or embarrass those who exercise state power, and that's why the office had to be protected and the incumbent had to have reinforced protections. But he always, in his gentle way, made people understand that this was for our own good, which Mr. Gwede Mantashe said recently that at times I had saved them from themselves. But that's in line with what former President Nelson Mandela said about this office. He said that even the most benevolent of governments have within them propensities for human failings, and that's why we've heard in the architecture of our democracy agencies to ensure that they hold government accountable and they help people to hold government accountable. It was therefore always understood that there will be some mistakes, and then there will be those who really truly didn't understand the Constitution and did not understand the law. But that would be the minority in the broad scheme of things. Except the issue of the powers of the public protector, I think there were more people who didn't understand the powers.
Well, we'll continue our discussion here on Rights and Recourse. If you'd like to join us, you can call us on 011 714 5497 or 5498. Alternatively, you can tweet us at Rights Recourse or send us an email at rightsandrecourse@sabc.co.za. Stay with us.
A presumed U.S. drone strike in the south of the country has killed 3 al-Qaeda suspects.
Death toll in Yemen's 18-month-old civil war now stands at about 10,000.
People get killed or die and are actually buried before they're recorded, and we don't have a way of recording that, but we know the numbers are much higher.
Water restrictions are to be imposed on villages in and around the Nkomazi municipality.
Pumps can't pump the water because there's no water in a river, and if the water is coming back, then it's full of mud.
Those who can pray and those who can do any miracle to make sure that we've got enough rain, give it a try.
Welcome back to Rights and Recourse. As we talk to Advocate Thuli Madonsela, actually bidding her farewell after a stint of 7 years, non-renewable stint of 7 years as Public Protector. If you'd like to join us, you can call us on 011-714-5497 or 5498. Advocate Madonsela, this is the view by many that you wake up every day and you decide the issues that you want to investigate. And the Public Protector Act sets out in Section 6, subsection 1, that any matter may be reported to the Public Protector by any person by means of a written or oral submission under oath. And this is where the Gogo Dlaminis come in.
That's very true. We don't wake up and decide what to investigate. In fact, 2 truths must be known. Firstly, most of the matters we've investigated were brought by members of the public. In the last 7 years, you'll find that matters that we investigated on our own or Meramoto would be no more than 20, and certainly never the kind of cases such as Nkandla or against the rules. The second thing is I'm not the one who decides what we're going to investigate. In the office, we have teams in 20 offices that do triaging. When a matter comes in, they check, is it within jurisdiction? Even if it's within jurisdiction, are we the best institution to investigate it? Or can we refer it to some other institution? Or is the matter too old for us to follow it up because the trail is cold or it occurred before we were established?
I don't want to skip all over the place, and now that you mentioned that it's a matter is too old for you to investigate,
yes.
I'm reminded there's been several calls for you to investigate the Bangkok Reserve Bank lifeboat issue that took place in the 80s and it was investigated by no less persons than Judge Willem Heath and Dennis Davis with no result. Why do you think people would insist that you investigate this debacle?
Well, firstly, I have investigated that matter. I've had to interview Judge Heath, Judge Davis, Judge Bertelsmann, the guy who wrote the CX report, Michael Oatley, former spy, UK spy, and I've interviewed Chris Scholz, former Reserve Bank governor, Tito Mboweni, ministers, former President Thabo Mbeki. I have done that. But what I didn't do was to look at what happened then with a view to looking at maladministration. The point of departure was whether or not the government of President Nelson Mandela did the right thing when it did not recover the money when the CX report said some of it was recoverable. Also, there's one of the peddling of information in the public out there is to say that all 26 billion was said to be recoverable. The CX report only focused on the Bangkok.
Can you explain what's the CX report? I saw it in my research, and
yes.
because I didn't understand it, I skipped it.
Yeah, CX is a company that was run by a former member of MI6, which is the UK spy agency, the equivalent of the state security agency here. He approached the South African government as a bounty hunter. A bounty hunter in this case would be somebody who investigates something for money and say, give me a percentage of this money if I find it for you. And he promised the government that he would find money overseas for the South African government that had been siphoned on the eve of apartheid. But when he was then given a retainer, he was being paid £100,000 pounds per month to do that investigation. 6 months later, he created this report that was brought to me by Advocate Paul Hoffman, who asked me to investigate why government did not implement. The first time it came, I rejected it, and Advocate Paul Hoffman was talking about how he cornered me on a bus in Barcelona and said, you need to rethink this matter. Please investigate its low-lying fruit. And I investigated because my team had rejected the investigation. The triaging team had said, no, we can't do it. It's too old. It happened before us. I then decided to do it myself because I couldn't impose a burden on a team that had said no. And periodically I've investigated with an intern, and then there was a time when we had no money after my intern had left, so I had nobody to help me investigate. As soon as I had one, beginning of this year, we resumed the investigation, concluded that investigation. My last interview was with Governor Chris Stolz and wrote a report. Unfortunately, before I left, I couldn't really put my signature on it.
So we might not see the, I don't want to cast aspersions as to whether we might see or might not see that report.
I'm certain that all reports will be seen. There's no reason why any report might not be seen.
There's no way, if a report doesn't come out, I can go to court and say, I want to see that report.
You can, in terms of PARJA. In terms of the Public Protector Act, a report of the Public Protector must be made public unless there are compelling reasons to make it secret.
How do you approach, say I come to you with a case to investigate. How do you approach the investigation? Where do you start? Probably like at least a case like the Bangkok case.
Yes.
There was a report. But where do you start when there's no report?
When there's no report, okay, firstly we triage it and decide whether we have jurisdiction. We normally do want something tangible though to work on. When somebody just says, oh, somebody has captured the state, for example, and there's no document, no trail to follow, we can't follow that. We normally want a document or a narrative that can be verified. In the early part of the report, we conduct what is called a preliminary investigation to just give us a sense of what is there out there. Is it worth following up? And if during the preliminary investigation we find that there is a cause to follow up this matter, we then follow it up. On the CX1, we started with a preliminary investigation, and once we had done that, it seemed that there was a basis for proceeding to investigate.
The Public Protector's investigation is not a court of law. There's no cross-examination. But how do we make sure the people who are giving evidence to the Public Protector are actually, what they are saying is verifiable?
We verify it ourselves. If somebody provides evidence, we then call you to an interview where we will ask you questions about what you said to us. We ask you to give us other persons who can corroborate your story. But mostly we rely on documents. If somebody gives us documents, we still have to go to the system to check whether those documents are authentic
Public
documents.
Protector, Advocate Madonsela, my apology, there's a call from Durban, from Charles. Charles, good afternoon and welcome to Rights and Recourse.
Hi, good afternoon to you. I love your program, and you know that you are such a cool person. And I think Advocate Thuli fits in the same zone. Cool, calm and collected and down to earth. But I think Advocate Thuli set a very high bar for the new Public Protector, because her ways are quite different from the new Public Protector. Advocate Thuli is guided by the powers and I, by the Holy Spirit, and she is down to earth, and she handles everything so wonderfully within reason. So I was wondering if she can sort of get round and advise the new Public Protector to be kind and understanding to the peoples of South Africa. That's all I've got to say. Thank you so much.
Thank you, Charles. I don't know whether I actually structured this program such that we don't talk about the new Public Protector, because I don't think we'll talk to her later once she has warmed up the chair properly. But I think we've got another call. Just help me. We've got another call. Danny?
Hello, how are you, sir?
Fine, thanks. How are you, Danny?
Yes, I just want to know I just want our public protector to clarify two things for me. They are saying that the maladministration, unlawful expenditure of 4.5 million rand. I just wanted to clarify. And also the accuser of using outside people in the office to investigate. So just wanted advocate to clarify us on that one.
Thank you very much, Benny. I don't know, I couldn't hear you properly. I don't know whether the Advocate Madonsela heard you properly. I don't know. I didn't hear Danny properly. I can't relay what he was saying.
I heard a bit of what Danny said about the 5 million or 7 million from USAID. The accusation that I have used donor money.
Oh, that's
and it has influenced the decisions. Firstly, no donor can ever influence your decisions, because investigations are transparent. As I've indicated, the process of triaging what you're going to do is a transparent process, and the Public Protector is not involved. These are received, they go to a registry, and teams in 20 offices decide what comes in and what doesn't come in. And so the Public Protector gets a report. She or he may then say, I don't agree with what has come in, but it's still an open process again. You will send your response through an email that goes to several people, and that goes to all offices in the country to say, I don't agree with this one, please take it in. Such a transparent process. No donor could possibly influence that. The actual investigation process is more like the police. It's the teams investigate, and the Public Protector is informed in a think tank what's going on, and towards the end then you work with the Public Protector. But it's a group thing again. It's not possible that any donor could get involved. But let's go straight to the issue of USAID.
Let's hold that question for a moment. I think I'm told I must go to an ad break. If you'd like to join us, and the Public Protector will come back to explaining to us about the issue around the donation from USAID. When we come back, you can call us on 011 714 5497 or 5498. Alternatively, you can email your thoughts to Rights and Recourse at sabc.co.za. Stay with us.
Police found powerful military explosives when they swooped on a house in Springs on the Gauteng.
Some of the weapons seized at this house included rocket-propelled grenades, rifles, and even rounds of ammunition.
All military explosives that we found that you cannot obtain a commission.
The weapons found at the house not only had the potential to cause major damage to property, but they also put many lives at risk.
I could have lost any one of my family members, or most of my family members.
Welcome back to Rights and Recourse. As we continue with Advocate Thuli Madonsela, looking at her legacy and the stuff that came out after she was leaving office. Let's take this call from Jackson from Pretoria. Jackson, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir, and how are you?
Fine, thanks. How are you?
Fine. Well, what I want to say is just to congratulate your program, because it really gives us a brief note of what is transpiring within the public protector space. So it's of my understanding that via Thuli's exit towards the time in which he had to exit the public protector space, that's when people started to beef up their security. Imagine if someone has to hire double times the security while people are crying tears out there. The country is burning. The next thing, someone beefs up his security. Where do you think that money comes from? If Thuli had to ask for the money from the donors, while he had requested the money from First Go, and he was denied the monies, and the money had to be diverted to the transportation of the president, what do you think of that? That's all what I want to say. Thank you.
Thank you very much. I didn't get the gist of that question, but surely he was talking about people beefing up their security. Did you have to beef up your security?
No, I think, well, thank you for the compliment, but I think that's an issue about the beefing up of security of the president as the head of the executive, but let's not go into that. I would rather answer the USAID question.
The USAID question is far more important for me.
We haven't used any money from USAID. So any suggestion that we got money from USAID and we've used it and that's what has influenced our decision is misleading. I did ask money from the donor community as a whole. By the time I left, I'd had 2 donor conferences where we indicated that we needed money primarily for our case management system, digitalized case management, and we were looking for 50 million rand. In response to that, USAID gave us a crumb of money that was already within the Department of Justice. They pledged that the Department of Justice could give us about $500 US of what was left in money that had already been given to the government of the Republic of South Africa by the government of the United States of America. We then had to negotiate what do we do with that money, because it wasn't big enough to deal with what we had asked for, but we still wanted to use it to improve systems, to re-engineer our systems, to ensure that even though we have little, but we can do more with little. And we had just concluded that process of looking at where can that money go. And donor money, we've always said it can't go into core business. And that was part of this negotiation process. By the time I left, we hadn't used any of it because we had just concluded arrangements of what projects would be covered by that money.
Let's take this call from Thabo from Pretoria. Thabo, good afternoon and welcome to Rights and Recourse. Thabo is not there. Thabo is gone. It's probably phone cut. Sort of from the onset, you investigated, people started to take note of your office when you investigated the procurement of the headquarters for the SA Police. And how do you begin when police are very good at investigating themselves?
Well, certainly they are, but when it comes to being your own doctor, we all fall short of that, and that's why former President Nelson Mandela said we needed institutions such as the Public Protector. We investigated that because there was a complaint from the public, and we found indeed that there was maladministration in the procurement of those buildings, and we asked that the police together with DPW should go to court and request that that transaction should be reversed. And the name of the report was Against the Rules. That was the first backlash, by the way, where they fight back, saw me being accused of all manner of things.
Thabo is back on the line. Thabo, good afternoon and welcome to Rights and Recourse.
Good afternoon, Matthias. Good afternoon to Advocate Thuli Madonsela.
Good afternoon, sir.
Good afternoon.
I've got one question is concerning the state capture report. I just wanted to find out from the advocate as to whether she had, by any chance, shared her findings about the outcome of the state capture report, because it looks like people are running up and down, putting agent applications, because I told myself that maybe it's possible that you would have ruled that there is no evidence to support that there was state capture. But people are going up and down. It looks like they know that they are guilty or not.
Well, they say where there is smoke, there is fire. I'm not trying to suggest anything, but I just want to ask that question, I think, in another way that Thabo has asked. There's been a request by people to be given an opportunity to question people who give evidence on the so-called state capture investigation. But Section 7, subsection 9 of the Public Protectors Act is very clear that such questions have to be processed through the Public Protector. Am I wrong?
You're not wrong, sir. And in addition to that, it says, the Act says the process of the investigation must be fair, but the manner in which it has to be unfolded is the sole discretion of the Public Protector. For those who insisted that they wanted to cross-examine witnesses, we asked them to submit questions to me so that I could put those questions to the people who they wanted to ask those questions, and then I would have then submitted the answers. If we are in a room in these inquisitorial proceedings, we don't allow people to be ravaged by the opposition in the name of examination. We ask whoever has a question to submit it through me as the presiding officer, and then in a gentle way I put it to the other party, because we don't want evidence to be tainted by the fact that some may be aggressive and some may be more combative. We create a level playing field. But on this one, regarding the Act, there's another section of the Act, Section 7(4)(a), which allows me to request answers from anybody who works for the state and anybody who is in the Republic of South Africa to answer questions, and I did the same to the President. Regarding whether we did communicate findings to people, yes, we did communicate to people what we said are potential findings if they don't give me answers that tell the story from their perspective, which answers were then going to be evaluated together with the evidence I already had. And if it turned out that the evidence I had was wrong, I would have then arrived at different conclusions.
Let's take this call from Anna from Johannesburg. Anna, good afternoon and welcome to Rights and Recourse.
Good afternoon, Dumile, and to Advocate.
Good afternoon.
Yes, ma'am, I don't know whether to address my problem to Thuli or to you, because just when I was still working on wanting to submit my complaint to Thuli, she's out of her office. Maybe she can advise as to how to go about. A problem is about these the dead councillors who are abusing the public, trying to help them, but in the meantime they put them into big trouble.
Is that it, Anna?
I beg your pardon?
Is that it? Is that all what you wanted to ask?
Yes, I want to know the public to the Public Protector I don't know. I wanted to know how to go about these dead councillors. You go to a dead councillor because you are desperate, and they claim to help, but in return they put you into deeper problems.
Okay, thank you. That's another Gogo Dlamini type question.
Yes, ma'am. You can lodge the complaint with the Public Protector because the office hasn't left, only I have left. There is already a complaint that was lodged by Ms. Wendy Applebaum, the one who took the
I remember that
companies.
case, the case around the garnishee orders.
Yes, part of that complaint is also against the National Credit Regulator and the need for tighter regulation of the debt councillors. Our Western Cape office is dealing with it, and if our colleague does submit that complaint, it will be integrated in the investigation that is already taking place.
I know you said you do not want to use the Nkandla report as the branding, is the report that branded your office. That initially it's like the Oscar Pistorius case. It made people want to know more about what's in this constitution, this book that I normally carry when I come to the studio.
No, that's true. We cannot deny that Nkandla case brought the office's presence to the last of the people of South Africa who may not have known about us, and it also brought us to the global community. But its main significance is highlighting the powers of the Public Protector, the binding nature of the powers. But there's another part of that report that we forget. It was the duty of members of the executive to act ethically and to protect the public interest in everything that they do.
Yeah, based on that, are you satisfied that our Parliament recognizes the supremacy of the Constitution and the fact that we are a constitutional democracy and not a parliamentary democracy?
I think before the Nkandla or the Secure in Comfort report and the Constitutional Court judgment in the EFF matter, there were concerns that the tone and the language being used in the debate about the Nkandla matter seemed to suggest that many members of Parliament thought that we were a parliamentary democracy. I hope there that after the EFF judgment, we all understand that we are a constitutional democracy and the Constitution is supreme. Nobody, no matter how important and no matter how level they are, is above the law.
Let's take this call from Anonymous. Anonymous, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir, and good afternoon to you, Advocate Madonsela.
Good afternoon, ma'am.
Good afternoon.
My question is around what you were recently reported to have said around the issue of employing consultants in the Office of Public Protector. You were reported as having said there was nothing maladministration about the use of consultancies. And you went on to say, because you did not have forensic investigators in your office, you therefore have had to, delegate authority to other people who would be able to assist you with that. The question that I would like to put to you is, I understand that. However, would you not have had an opportunity to employ people with those necessary expertise so that you don't have to use those consultants, but that you would have people within your establishment? And I think recently you had advertised for some positions.
Thank you, Anonymous. Is that it? Can you answer the question now?
The question is, Advocate Madonsela was in the office for about 7 years. Wouldn't she have had an opportunity to employ people with the forensic capabilities as investigators?
Thank you very much, Anonymous. I will allow Advocate Madonsela to answer that question, but goodness me, people might be falling over each other in that office.
No, but can I answer? I'm glad that Anonymous has asked this question. In 7 years, I did more than that, than trying to employ people with forensic capabilities. We've had our staff trained as food examiners, but there's a difference between having forensic capabilities and being a forensic expert. It takes a while to develop a forensic expert. I was only using the forensic expertise as an example. Right now in Baboba Mokale, we have 2 experts that are concluding the investigation. One is a forensic auditor, the other one is a quantity surveyor. We can't have quantity surveyors full-time in my office. We need them for specific cases. Recently, we needed people to test nuclear exposure from the Pelindaba people.
Pelindaba case.
And we couldn't employ them full-time. So it's been also doctors needing to examine somebody to see whether it was the hospital's fault. But I'm not the one who's giving myself powers to delegate some of my authority to people outside. It's the Act. If I had decided that I would never use consultants, I would have constrained my own powers. And in the Mail and Guardian case, the court said that the Public Protector has enormous power, and it's not for the Public Protector to constrain those powers. You've got to keep them open, but use them judiciously.
Well, if you'd like to join us and ask the questions that many are asking, even if you want to say farewell to Advocate Madonsela, you can do so on 011 714 5497 or 5498. Alternatively, you can email your thoughts to Rights and Recourse at sabc.co.za. Stay with us.
Now this is Trends, of course, your one-stop serving of all that's juicy and trending in the world of entertainment and showbiz. My name, of course, is Refiel Wemulov.
I'm Dr. Sello Mutaung, and this is our talk. A very good morning and welcome to Media Monitor. I'm your host, Alicia Jali.
My name is Dumile Matez.
What time is it? It's question time.
For your daily dose of current affairs, tune in to the SABC News Channel.
Welcome back to Rights and Recourse as we discuss the legacy of Advocate Thuli Madonsela as Public Protector of the Republic of South Africa. Let's take this call from Paul in Northwest. Paul, good afternoon and welcome to Rights and Recourse.
Okay, good afternoon. How are you?
Oh, thanks. How are you, sir?
Good afternoon.
All right, and I should also pass my regards to Madam Madonsela. My few comments. One is on the power and the privilege of the office of the Public Protector. The one thing is that if they were under a ministry, the powers would be on that ministry to make sure that things are done accordingly. But now it's a standalone, so the powers reside within the office. How was the balance between managing the power and still being within the Constitution?
Is that it? Thank you, Paul. I don't know whether that was very clear.
I understand. It's the same way that the powers of a judge are exercised, that you use your powers judiciously and you make sure that you are guided by the Constitution. And in our case, for example, I explained earlier that it was never my understanding that my job is to protect the state. I always understood that my job is to protect the people from abuse of power and from just misbehavior by the state, and to help the people to protect themselves. Should I exceed my powers, like anybody who exercises public power, there are checks and balances. The first check and balance is Parliament. Parliament can question your abuse of power if you are the power protector. But if it is relating to the exercise of my powers as an investigator or as the head of investigations in the power protector office, the protection that the people have are the courts.
I just want to ask a question. You may answer it if you don't want to answer it. Are these, we're just as interested. People will slaughter me if I don't ask the question. We're very interested. Are the issues ventilated in the Minister of Finance affidavit around the closure of the bank accounts of Oak Bay contained in the state capture report?
I'm not at liberty. I would be disobeying the judge if I started talking about what is in the report. We were asked not to say what is in the report, although of course the affidavit of Minister Van Rooyen has been withdrawn because he's the one who had said we can't comment on the report, we can't say a thing. But I still think in respect of the judicial process, I shouldn't say what is in the report.
Well, we respect that.
Yes.
Since the publication of Encounter report, Secure and Comfort, there has been accusations thrown at you being a spy of the CIA, and did the subsequent investigation by the state security yield anything? Did that not endanger your life, or does it bother you? Or did it bother you?
I was bothered by the fact that as I was busy investigating, people sort of started lighting fires behind me to sort of distract me from doing my job. And it has happened when it's high stakes investigations, starting with Against the Rules, then Secure and Comfort, and then with this one also the
state capture.
The state capture. I really have never experienced so much wars being declared against me, from NGOs being started just to go and lodge some criminal case against me, to resurfacing of a blog again that calls me a spy. Yes.
You have been threatened with arrest on several occasions. One such threat was with regard to your activities when you were Commissioner of the South African Law Commission.
Yes.
Can you remember what this was all about?
I remember that was the backlash during the Against the Rules investigation, where it was said I'm about to be arrested for fraud and corruption for having had a tender from the Department of Justice for 1.83 million. I will still remember the amount because my team had to run around and say, I don't remember that tender. It turned out that within 10 years of doing different projects for the Department of Justice, some of them for free, some of them for 30,000 rand, amounts paid to my company at the time had totaled that kind of money. But all of that had happened whilst before I was in the South African Law Reform Commission. Once I was in the South African Law Reform Commission, they had bought books for about 30,000 rand from my company. And yes, but it's been the nature of this business that people think that when they are under scrutiny, they should fight back and fight dirty.
You also intimated at some stage that you were under investigation from the Hawks. What became of that?
That was bizarre because, they now came back to the public and say that they never investigated me, yet they did. We even had to hire a lawyer, which would be fruitless and wasteful expenditure. That was the only time I hired a lawyer when I was under scrutiny, because they were interfering with the court process. In court, there were two matters. The SABC matter in Cape Town, where I had said the powers of the Public Protector are binding, and the Home Affairs matter in Pretoria, where I had said the powers are not binding. It's a long story about why I didn't read the Pretoria affidavit, but then they were saying I perjured myself. Perjury is when you tell lies, factual lies, but interpreting the law in a constitution that the judge has can't be an issue of perjury. But we were shocked that when this matter went public, that the Hawks said they never investigated. They assigned two senior people, kennels, to come and interview staff in my office. And there was toing and froing of letters or legal documents between my office or our lawyers and them.
After the Cape Town judgment by Judge Skeepers, it had to be proven what happens to the remedial action of the Public Protector. Therefore, the case of the Constitutional Court and the Supreme Court of Appeal had to take place.
No, absolutely. It had to take place because we disagreed with the finding at the time that the powers were not binding. And Judge Skeepers was gracious enough during the appeal judgment to say that the powers of this office are extremely important, and there's a possibility that he may have erred in deciding that the powers were not binding. And then when it went to the SCA found that the powers are binding. We never took the matter to the Concord because those who were appealing didn't take it there, but the EFF judgment on the secure in comfort investigation then took it to the Concord, where the finding of the Constitutional Court was more far-reaching than the Supreme Court of Appeal. The Supreme Court of Appeal had said the powers have legal effect, and the Constitutional Court specifically said a decision of the Public Protector is binding if he or she means it to be binding.
The other question you might want to answer it or not, which I have to ask, is it's been reported that the incumbent Public Protector is not going to challenge the President's indictment. Did the Office of the Public Protector, when you are still there, not prepare a responding affidavit to this challenge? But because if there is a responding affidavit, it is the office that has to place this on record.
I choose not to interfere with the exercise of powers by the new Public Protector. When I was Public Protector, Advocate Mushwana assisted me with just telling me what he had decided and why he was challenging the mail-in guardian case, but he left it to me to decide how to proceed. And the new Public Protector hasn't consulted me on why I made the decisions I made, but that's a choice she has made, and she is the only Public Protector in the Republic of South Africa.
You have been bestowed with many we have been feted internationally by Times magazine as among the 100 most influential people in 2014, the New Africa magazine, 100 most influential people in Africa, Transparency International. I was reading earlier that somebody was making a suggestion that you should get a doctorate. So you have all of these things. You've got all of these things. These decorations around you.
I do have those decorations, but although they've been bestowed on me as a person, they are recognizing the work of more than 300 men and women who have dedicated their work to making that office, to make the difference it was meant to make. There's no chance, even if I was the smartest person on earth or the most industrious person on earth, to have even avoided criticism if it wasn't for the commitment of the people I worked with.
What's the future? What does the future hold? No less a person than the Deputy Judge President of the North Gauteng High Court recently thought that a person of your caliber should submit her name for a position in the judiciary. And he says, we are aware that you will be joining, I'm aware that you'll be joining Stellenbosch University. Would you consider something like that in future?
Well, I think it was gracious of Judge Aubrey Ludwaba to say those kind things. But right now, I'm more concerned about just taking a sabbatical for 15 months and then going back to teach the young ones. Because what shaped me, what shaped my sense of justice and wanting to make a difference in favor of social justice with my early teachers, such as Professor Thandabantu Nhlapo, Pat McFadden, etc. And I want an opportunity to do the same with some of the young people I will work with at Stellenbosch. I'm happy you say Professor Thandabantu Nhlapo was your mentor, and I think he owes me an interview which you've been talking about for some time now. You must be thinking by now that what is going to go, there's a lot of stuff that will go into your memoirs. Well, there is. I will use the 15 months to also sift what is appropriate to disclose and what is not appropriate to disclose. You always have to do these things judiciously, and you can't offer information gratuitously because some of it was given to me in confidence.
No, what you say to me, it was done. All the accolades you got was for the office. All the trophies you got, you left them in the office.
Absolutely. Well, I think I probably did take the trophies because they had my name on them. But to be fair, it was recognition of the dedication and achievements of the team. In fact, the last letter I read at the last media briefing that I did, the complainant whom we had helped in a matter that was really difficult. He had lost everything. They used to come with his wife to show us what their life looked like before maladministration and what it looked like then. He wrote this letter and specifically indicated that it was what I did and what the rest of the team did, because it really is team effort that has made that office to make the impact it has made over those years.
Quickly, I notice you might also choose not to answer this one. I noticed that there's still no love lost between you and the Portfolio Committee for Justice in Parliament. When you were supposed to present your annual financial report, they cancelled the meeting whilst you were on your way to the airport.
Well, I hope there was no malice, because that would be abuse of power, because public power should always be exercised in accordance with the law and for public interest. I want to believe that the committee had good reason why a meeting was cancelled. But I must say, though, putting the new Public Protector in a situation where she had to defend my report was unconstitutional, because the Constitution is clear about he or she, and the Public Protector Act is clear about he or she, because surely I can't account for your actions. You have to account for yourself. It's also a basic principle of administrative justice that you have to explain yourself.
Advocate Thuli Madonsela, thank you very much for your time. It's been a riveting discussion. I never thought I would actually enjoy it. I said to the team here, somebody who's come here, she talks very slowly, she's very gentle, but we must also be gentle here. Thank you very much for your time. We wish you all the luck.
It's been an honor.
Future endeavor. In March this year, the Chief Justice of the Republic of South Africa, Mogoeng said one of the crucial elements of our constitutional vision is to make a decisive break from the unchecked abuse of state power and resources that was virtually institutionalized during the apartheid era. To achieve this goal, we adopted accountability and the rule of law and the supremacy of the Constitution as our values of our constitutional democracy. For this reason, public office bearers ignored their constitutional obligation at their peril. This is so because constitutionality, accountability, and the rule of law constitute the sharp and mighty sword that stands ready to chop the ugly head of impunity off its stiffened neck. The views expressed in this show are not necessarily those of the SABC nor Rights and Recourse. The program is repeated at 5 on Wednesday morning. You can also find us on YouTube. From me and the rest of the team, goodbye.